Hello everybody, how are you? I hope you're all well. When Shane talks about future-proofing a business, what I mean by that is making sure that you can run your business in a way that both improves your profitability and also helps you to weather the kind of storms that hit small businesses especially, but even medium and large businesses. So your biggest risk that you can, one of your biggest risks that you can face as a business owner is the risk brought about by staff coming and going, by leaking of information, and by having even third parties, suppliers, independent contractors, having access to information that can then be used to, in fact, compromise the way in which you do business. So today we're going to have a look at both restraints of trade and confidentiality agreements. You'll see that they flow together quite nicely. And the idea here is to give you an idea of what a restraint of trade is, and whether or not it's enforceable and how we can enforce it. So I've asked Shane to run 2 polls. I'm actually going to ask him to run them now. I don't know whether or not you have got a restraint of trade clause in any of your agreements. And I'd like you to answer yes, no, or you don't think it applies to you. And the other poll is whether or not you've ever tried to enforce a restraint of trade. And you can just say yes or no. I'm not immune to the various complexities that come with restraints of trade and staff. I've had my own concerns about that. I've had my own staff leave and take information. And people are often quite scathing of confidentiality and restraint of trade agreements. So today what I want to do is just demystify them and show you how we can help you to actually protect those which are that which is important, which is the heart of your business.
Well, so there we go. The results of the first poll. Do you have restraint of trade? We've got the majority, 44%. So that's nearly half, 4.5 out of 10 are saying, yes, I do have one. Then we've got a third, 32% saying, no, I don't have one. And then 24% have opted for, I don't think it's relevant for me. So that's great. Your comments on that?
Yes, I think it's not surprising. A large majority of people have a restraint of trade clause. Often what happens is that's not something that is relevant to their particular business, so it's very hard to enforce. And I know that you're all going to look embarrassed and look around the room, but very often people download off the internet various clauses, so they find out they need a restraint of trade, or they think they need a restraint of trade, but they don't want to pay anyone to do it, and so they download a clause off the internet, pop it into their agreements, which they've also downloaded off the internet, which I can understand, times are tough. And then they have a beautifully dysfunctional agreement, which helps no one. So it's not at all, it's exactly what I thought. The no is actually higher than I thought, and not relevant is about right. You'll see that people often avoid restraints of trade, either because they don't find them to be relevant, or the common misperception is that they're not enforceable at all.
So there we go. The results of the second poll. Have you ever tried to enforce a restraint of trade? We have got, and it's a resounding majority here, 90%. That's 9 out of 10 people who have voted have selected no. Only 10 have gone for yes.
Yeah, that's absolutely, completely normal. So people don't enforce restraints of trade for various reasons. As I've said, it can be very daunting, it can be expensive, but also people feel, oh, well, I'm never going to win. The ones that do enforce their restraints of trade often do go to an attorney immediately for advice, and often do understand what the value of a restraint of trade is. And when I say understand, I don't mean that in a patronizing way. I do law. I can't do what you do, Shane. I can't do what any of the band franchisees do. In fact, you want me as far away from your finances as possible. And essentially, we all do what we're good at. And sometimes what happens is we have to make a call in the cut and thrust of business. and we make a decision in the moment, having not properly researched or taken advice, and that's absolutely part of how business goes. And one of the purposes of today's webinar is just to empower people to know what to think about and how to proceed. So I completely understand and I completely accept those figures. They're exactly what I would have thought. Oh, I'm already going off my first slide. Okay, I'm going to continue if that's okay with everyone. Shane, are you there? Start with the definition of a restraint of trade. So unfortunately, this is one of the areas of law where I can't get around case law, which is so boring it will make your eyes bleed. And I also can't get around some quite technical definitions, but I will try and make it fun. If it isn't fun, please let me know. I'll send you some booze after the webinar to make up for it. But we do have to go through some of the more boring or some of the more clinical, shall I say, aspects of law. So a restraint of trade is not something that's governed by a statute. It's not governed by an act. There's no restraint of trade act. So it's governed by what we call the common law. So the common law is what courts build up around a concept. So for example, if in the case of restraint of trade, there will be these provisions, a restraint of trade provision in an agreement or in a series of agreements, and these agreements go to court. And over time, the court builds up a body of law around a specific topic. So a restraint of trade, it doesn't fall squarely into employment law, although it's often used in employment agreements. It's actually often used in shareholders agreement or share subscription agreements, where you don't want your shareholders or directors to come out to leave the company and go and start up a competitive venture. So it's not only in employment agreements. In fact, in shareholders agreements, it becomes extremely important. And so it isn't something that falls squarely in labor law, which is governed by various acts, and it isn't something that falls squarely outside of labor law. So it's a bit of an anomaly. So the courts have defined a restraint of trade as a contract in which one party, who is the employee, in this case, agrees with another party, the employer, to limit or restrict his future freedom to trade with another external party who was not a party to the employer-employee contract. So for the purposes of this webinar, I'm dealing specifically with employer and employees, but there are other relevant parties that may be constrained. So essentially, what you're saying is that if you employ Betty Sue in the future, if she leaves your employer, is not going to be able to trade or to practice her business as freely as she would have before she worked for you. Now, we're going to go through that quite carefully. So this is a balancing act. There's a concept of public policy in our law. So public policy is something that the courts look at. So is it good for society? Is it bad for society? It's a very complicated inquiry. It's some parts of, and it's an objective inquiry. In other words, it's not, do I feel that it's a good idea or do I feel like it's a bad idea? It's objectively looking at society as a whole and the way in these kind of contracts are interpreted. Is it a good thing for society or a bad thing for society? So the courts have to balance two competing claims. The one is what we call the sanctity of contract. The Latin is pacta sunt servanda, which means the contract must be enforced. So parties who say that they're going to agree to things in a contract must then perform in terms of that contract. It's not good for society to have people breaking their contracts left, right, and center, because contracts provide certainty, and contracts also allow people to plan their own businesses and their own lives around what's been agreed. On the other side, you've got public policy. And here we're looking at how important is competition. So the courts have held that competition is very important in a healthy economy, and I think we all accept that. If we look at things like Telkom and Eskom, and they are very good examples of what happens when there's not healthy competition. And then the other thing is the provision of the Constitution. So in terms of the Constitution, every person shall have the right freely to engage in economic activity and to pursue a livelihood anywhere in the national territory. So the courts have to balance the fact that people give up rights and incur obligations in the contract on the one hand, and that society requires free trade and a healthy economy on the other. So those are really your two, what we call competing considerations. So the question that I always get is, are restraints of trade enforceable? Or more accurately, I get, restraints of trade are not enforceable, they're a waste of time. You know, nobody can stop anybody from doing anything. The country's going to the dogs, and then, of course, everything else that flows from there. So I just want to start by saying restraints of trade are enforceable. There's nothing in our law that says that restraints of trade are not enforceable. The enforceability of a restraint of trade becomes complicated under two circumstances, and we're going to deal with each of these carefully. The one is where you try and draft the broadest ever in the whole world restraint of trade that prevents somebody from essentially breathing once they have left your employ. You cannot throw the net so widely that the person basically has to be unemployed for the rest of their lives. And the other side of it is that people don't act quickly. So if you are aware that there's going to be a breach of or you suspect that there's going to be a breach of your restraint of trade provision, you can't sit on your hands. It's an urgent matter. It's got to be dealt with urgently, and you are going to have to most likely seek the advice of an attorney. So yes, it then takes on a layer of costs, and the commercial reality is you always have to weigh up the costs of legal advice against the costs of losing or weakening your position as a business. So the seminal case that deals with this is Magna Alloys and Research versus Ellis, and it's a 1984 case, and it was heard. Well, yeah, the first court, the High Court, ruled in favor of Mr. Ellis, but the Supreme Court of Appeal then turned the ruling on its head and really laid the groundwork for the law in this area. So what happened was Mr. Ellis sued Magna Alloys, who was his former employer, for an outstanding commission. So he was owed commission for sales by Magna Alloys, or he claimed he was, and Magna Alloys brought a counterclaim for damages and sought an interdict, restraining him from continuing to act in breach of the restraint of trade. So just so that you can impress your friends at the dinner table and sound like you're an extra in suits, a counterclaim means that within the same legal case, one party makes a claim and the other party says, well, firstly, I don't think you have a claim, or I think you have some claim, but I also have a claim, and it's bigger and better and scarier. So those are counterclaims, and damages are what you lose or what you have suffered from a financial perspective as a result of somebody breaching a contract. So if there are any other lawyers on this podcast, or if you're going to talk to any other lawyers, I warn you now, this is obviously a very simplified discussion of the law. Unless you want to sit with me and go back to Roman law, I think this is more than enough for now. Okay, so in terms of the agreement, Ellis essentially agreed that for 2 years after the contract terminated, and within a radius of 10 kilometers, he would not directly or indirectly, sorry, let me just, I've got to keep moving my little poll thing here. He would not, as a partner, employee, agent, salesman, or representative, engage with any competition to Magna Alloys. He would not sell any substance or material that was similar to or the same as there was an annexure to the restraints and set out the material. He could not seek or solicit customers or business for the sale of such product, and he could not promote or financially assist any other person, firm, association, or corporation engaged in a business that competed with the business of Magna Alloys. Okay, so what then happened, and then in addition, the contract said that if he breached the terms of his agreement, Magna Alloys would suffer damages at the rate of 250 Rand per week, bearing in mind this was 1984. for each week that he violated the provisions, and this would constitute a genuine pre-estimation of damages. So we're going to put that aside. Pre-estimation of damages is a whole nother webinar on its own. But essentially, they said that they would suffer damages, and this is how they estimated their damages. So the courts, sorry. The courts went on to say that there's absolutely nothing in our common law that states that a restraint of trade agreement is invalid or unenforceable. So the starting point is that this agreement is enforceable. You can enforce a restraint of trade. Where the misconception often comes in is that before this decision, you could not at all enforce a restraint of trade. So before 1984, you couldn't enforce a restraint, primarily because it came out of an English law concept. So people were getting confused, probably because they were doing the equivalent in 1984 of downloading things from the internet, which would probably be stealing books from the library, I have no idea. And they were assuming that these things were not enforceable. However, it is also a principle of our law, the courts are making this ruling, that agreements which are contrary to the public policy are unenforceable. So we've spoken about public policy. We don't want people being constrained to add to an economy. So it says a restraint of trade is unenforceable if, in the circumstances of a particular case, the enforcement of the restraint of trade would be prejudicial to the public interest. So that tells us two things. Firstly, that it's on a case-by-case basis. There's certain general principles, but that a court will look at the specific case on its specific facts. And the second thing is that you have to, the court's consideration will be whether or not there's going to be prejudice to the public interest. And public interest changes from time to time. So what was in the public interest, 60 years ago is not necessarily in the public interest today. So 60 years ago, you had legislation and law around homosexuality, around people of different races, in marriage and all of those things. So public policy from 60 years ago is not public policy today. So it does change. And then it was also, they also found that it was in the public interest that agreements entered into freely should be honored. So you can't go around just breaking, not enforcing agreements because you just don't feel like it. And that's, again, in the public interest, it's balancing on the other side. You need to be able to operate freely in the commercial and professional world. And it also needs to be accepted that a restraint of trade, an unreasonable restraint of trade, would prejudice the public interest. Okay, so if your restraint of trade goes broader than is necessary or is unreasonable, then that's also not in the public interest. You can't enforce agreements that are essentially going to enslave people to their employers, much as some employers would find that very helpful. So if you allege that you are not bound by a restraint, you have to bear the onus of proving that that restraint is contrary to public policy. Now that's very important. So if I sue you, if I'm a business owner and I sue one of my, and I institute court action against one of my former employees to enforce a restraint of trade, it's up to that employee to show that the enforcement of that restraint of trade is contrary to public policy. So again, the courts have to look at the circumstances existing at the time that the enforcement is sought. And this is, the last thing is very unusual for a legal principle. And it's called the blue pencil test. I don't know why it's called the blue pencil test, but it is called the blue pencil test. In other words, the court is not constrained to either enforce the whole contract, the whole clause, or at all. So it can say that some of it's enforceable, some of it's not enforceable. So that is quite an interesting finding, and it means that even today, if you've got a restraint of trade where some of it is ridiculous and some of it is okay, the court can enforce some, if not all, of the restraint of trade provisions. So what we've really looked at now is the fact that what the courts have to consider. So those are the things that you have to look out for with regards to drafting your agreement. So you have to look out for being unreasonable in the breadth of your restraint of trade versus protecting what is, or enforcing protection around your business and your business interests. But there is what we call a threshold inquiry. So a threshold inquiry is, can the business meet, before it wants to enforce its restraint, can it meet this very bare minimum? And that is, does the business have a protectable interest? So a protectable interest is not, I just don't want my employees to compete with me. It's actually, do they have a protectable interest, something that can be, that is worth going to court, or not is worth, that you can go to court to protect. So they fall into two main categories. The first is relationships with customers, potential customers and suppliers. So they refer to as the straight connections of a business, and it forms part of the business's goodwill. The second is the confidential information that, if disclosed to a competitor or to the market, would result in a business losing its competitive advantage. That's also known as trade secrets. So the first thing to look at is, when you look at customers, potential customers and suppliers, that's not just lists of who these people are. Because if I, for example, wanted to make a list of all the companies in Cape Town that might need my legal services, I could go on to Google and I could search private companies Western Cape, and a whole lot of companies would pop up. So I can't say to any of my staff, you may not take a list of companies that I have compiled with you. What we can restrain as business owners is how that relationship is governed. So things like price lists, calculating the manner in which the business relationship adds value, the types of services that are offered to that particular client, and how those types of services are uniquely offered. So not offered in a way that everybody offers services, but offered in a way that is unique. Because regardless of what we like to think as business owners, very little of what we do is bespoke or unique. So unless you have come up with something that is specifically that is specifically unique to your business, you're going to struggle to enforce that protectable interest. But there are other things that you can look at. So I don't want you to disengage from the webinar because you need to go and cry into your cauliflower mash. We will fix that, don't worry. And the second thing is then your trade secrets. This is pretty easily determined if you are, for example, KFC and you have your 11 herbs and spices, or you are Coca-Cola and you've got your secret recipe for Coca-Cola. But for the rest of us, unless you are in a business where you have trade secrets ranging from intellectual property that you want to protect to a specific methodology or internal system that you use to do business, it's going to be quite difficult to protect your trade secrets. So certain things are obviously easy. They can't use your business name, which is an intellectual property right. They can't use your logo. They can't say that they work for you. So that would be things that would help your former employees gain a competitive advantage. But it's not a secret. A secret is something that, if it leaked into the public domain, it would irreparably, or even for a short period, damage your business. So what can't you protect? You can't restrain an employee because you don't want competition, all right? You can't decide that Betty Sue, for example, I can't say that one of my previous employees can never be a lawyer, all right? I can't stop them from practicing law because I don't want competition. And one of the reasons I can comfortably say that is that there are 27,000 other lawyers in South Africa who are technically my direct competition. So 27,001 lawyers is not going to tip the scale for me. If, for example, I was doing something extremely bespoke. I mean, I happen to think that my services are very bespoke and awesome in many ways, but the truth of the matter is I'm offering legal services and other lawyers also offer legal services. If I was doing something very, very, very specific, so I had software that allowed me to predict the outcome of litigation, or I had certain precedents or ways of doing law that were so fantastic and so unique to my business that no one else was doing it, that gives me something to protect, to say to those employees, yeah, you can go and be a lawyer, but you can't use these specific secret and proprietary things. You've also got to look at a restraint of trade being enforced where there's an actual potential threat to a business's protectable interest. So if one of your employees leaves to go and do something completely different, you obviously can't restrain them. You can't restrain them from doing something that doesn't immediately threaten you. So if you're only working in the Western Cape and they want to go and do something similar in Joburg, is that an immediate threat? That's the question the courts will ask. If it is, you're going to have to justify that. But you can't say, oh, one day I may go into Joburg. No, that's not how it works. It's at the time we want to enforce the restraint of trade, is this an actual threat or a potential threat to your business? Now, potential doesn't mean sometime in the future. It means if they were to take your information now and compete with you in the same jurisdiction now, is there a potential that they would threaten your protectable interest? So if you look at it like this, you can see it's not about preventing or holding an ex-employee back. It's about protecting key information or practices of the business. So I always say to my clients, think of it as a lager around your protectable interest and not a lasso to bring, or a lasso, it's spelled like lasso, but it's pronounced lasso. All very interesting, things you find out on Google. To pull the employee back into your business or to stop them from going forward. And the thing that you've also got to realize is you can't scrub someone's brain. So you can't unlawyer a lawyer. You can't stop people from having ideas that come out of even working with you, where they think, oh, actually, I can do this better. Those kind of things cannot be restrained. So as much as you may want your number one lawyer in your practice to not go into competition with you because they're really good, that you can't do that. You've got to show that there's actually something to protect, and that ex-employee or former employee or shareholder or independent contractor or client even, if they use that information, they will damage your protectable interest. So I hope that makes sense. One of the difficulties about a webinar is that I can't see you all nodding. I can't see you nodding very hard like you do when you're in a public one-to-one or one-to-one discussion. So there are certain components for a restraint of trade. And those components are things like confidentiality provisions, non-solicitation of clients, and non-solicitation of staff. So what does that mean? So these provisions often fall under a restraint of trade. So most people think of restraints of trade as being, you can't go and work for a competitor at the end. Now that is part of a restraint of trade. Okay, so essentially what you don't want is you don't want your staff running off and either competing with you unlawfully, in other words, taking some kind of unfair advantage out of from your business. So taking something that you've created and that is sacrosanct within your business. And also it's about not allowing your employees or protecting your business against unfair competition. So for example, if you and your competitors have always competed in the same market, and now suddenly your competitors got access to your information, will that give them an unfair advantage. Now, under the umbrella of a restraint of trade, you've got confidentiality provisions and non-solicitation provisions, which I always think are a very funny name, but for not interfering with clients or staff. But, you know, it is what it is. So when you deal with these, you can either have a comprehensive restraint of trade provision in your agreement, or you can have a confidentiality provision, or a non-solicitation of clients, or a non-solicitation of staff, or any combination of the three. So, for example, for me, I don't have a restraint of trade on my attorneys because essentially I can't stop them from being attorneys. But I do have confidentiality provisions because I deal with confidential information. And also there are certain things within my business that I have designed and I consider them to be a protectable interest. And I do have non-solicitation, so they can't go and swipe my clients and they can't go and swipe my staff. But that has to be properly defined, and we're going to get into that now. So what is a confidentiality agreement? A confidentiality agreement, unsurprisingly, is an agreement which keeps information confidential. You can see this is written by a lawyer. What is a confidentiality agreement? It's something that keeps information confidential. That's why you pay us the big bucks. There are three main principles. So the information that is covered by a confidentiality agreement needs to be able to be used in trade. So it's not what's not covered by a confidentiality agreement is what time in the morning I arrive at work. You know, that might be confidential in the sense that I don't want people to know that I arrive late after my Botox, but it's not used in trade. Okay, so you can't, for example, use information that isn't going to have any value to anybody else. That's not confidential. It can't be public knowledge or public property. You've got to be able to show that either only a few people know this or a closed group of people know this information. So you're not going to try and say that information that's within your entire industry is confidential. So what that means is your client lists aren't confidential necessarily. They are in certain industries, but generally who you're doing business with is not necessarily confidential. How you are doing business with them might be. It's got to be of economic value to the person seeking to protect it. You can't want to protect it because it's all very embarrassing. You can't want to protect it because it looks pretty. You can't want to protect it because there's some sentimental reason why you don't want other people to use it. It has to have some kind of economic value. And it doesn't become confidential just because you decide to call it confidential. Clients are very funny. So they think that using the word confidential or without prejudice are magic words that change things from what they are to what they want them to be. Just because you call something confidential doesn't mean it is. It's like just because you call your car a wagon, it doesn't make it a wagon. It's still a car. Or vice versa. If you're a candidate attorney, you probably ride a wagon and not a car. So the reality is that that information needs to be something that has a value to it. The other thing to remember is that certain protections exist automatically. So copyright, for example, exists automatically. When you write something down, with the exception of coding, which is another story, which anybody who runs IT businesses and does coding, you can chat to me offline because that's a whole nother story. The minute you write something, it becomes copywritten. Again, I am oversimplifying it. So if somebody uses your material that you've written, you don't have to go under confidentiality. You can go under infringement of copyright. You can also, if someone steals your training material, you can do the same thing. So it's not necessary for you to always go with confidentiality, and that's one of the reasons that where lawyers do make a difference, is as individuals, it's a bit like when I'm sick and I Google my symptoms to see what's wrong with me, and I always land up with like Ebola as opposed to a cold. Because what we tend to do is we tend to latch onto concepts that we're the most afraid of and that is most in the public domain and gossiped about or spoken about or misinterpreted, and we tend to think that that's our only way. Whereas if you sit in front of a knowledgeable attorney, that attorney can say, okay, yes, we can go under confidentiality. It might also be breach of copyright. You know, we have a look at what your different options are. And again, the courts have held that whether or not information is confidential is decided on the facts of each matter. It's not like every single recipe in a kitchen is confidential. No. Because if you make Melba pudding like everybody else makes Melba pudding, that's not confidential. But if you are known for your Melba pudding recipe, and it is the most distinct Melba pudding recipe in the world because you add chutney instead of apricot jam or whatever it is, that may well be confidential. So you can't, there's no category of things that are absolutely confidential. There's certain things are more likely to be confidential than others. So when I put in a confidentiality agreement without a restraint, you can put in confidentiality as part of a restraint, or you can put it in on its own. So if we then have a look at the non-solicitation provisions. So non-solicitation prevents actively poaching clients. This is a tricky one. You can't stop your clients from going where they want to go. And that is a reality. If your clients want to leave you, they will leave you. And yes, you can write to the client and say, if you do business with Betty Sue, who's under a restraint, we are going to bring, we're going to interdict you. But you don't want to do that to your clients either. If you haven't looked after your clients and they go with someone else, that's business, that's life. But if that person is actively pursuing your clients and saying things about you that aren't true, or about your business that aren't true, or in any way interfering with your client's relationship with you, you have grounds to go against that ex-employee. And that happens more often than you think. So people will leave one business and go to the competitor, and they will then phone the clients and say, oh, for 10 years I worked at Robyn Hey attorneys, and now I'm at, Peter Smith attorneys, and they're so much better. And do you know that Robyn Hey attorneys never does what they're supposed to, and they overbill, and they do this and they do that. And they essentially undermine that relationship. Or they say, if you come across to Peter Smith attorneys, we'll halve your bills. So it's that kind of interfering with a client relationship. So again, you can enforce your contract with regards to a non-solicitation clause when it comes to client. But there's also a common law remedy, which is really broad. It's a common law understanding. And remember, common law is something, again, that's not under an act. It's decided by our courts, or it's a body of law built up by our courts. And it's called common law anti-competition. So what that means is you're not allowed to, one of the many things it means is you're not allowed to interfere with the contractual relationships of other people. Absolutely, you can market. Absolutely, you can phone them. Absolutely, you can do whatever you like with regards to objectively marketing your service. But you cannot go and interfere with the contractual relationship. And that definition is also broad, but it's things, again, like undermining relationships, spreading rumors, doing things that are not honest. And under that, you've also got the common law concept of defamation. So when you're talking about non-solicitation of clients, there are quite a few things that you can do, but you also got to be careful how you deal with it, because those client relationships are gold. And if you go hard after a client, you will definitely chase them away. You can interdict your former colleague or your former employee, but I wouldn't advise that you threaten the client, because that can only end in tears. It's also important that you define a client. You can't define a client as every single person who has ever phoned us and we've ever done any work for them in the last 50 years, because then essentially nobody can do work for anybody. You've got to say, we often we often define it by means of time. So we say it's somebody who was a client of the firm in the last 6 months or 3 months or 18 months, whatever it is, because you can't prevent people from reasonably contacting clients of yours they may not even know they were clients, or they may have been clients 10 years ago and they haven't done any work with you since. those kind of definitions are important, and they go to reasonableness of the restraint of trade. The court is not going to enforce an agreement, or not easily going to enforce an agreement that says you can never ever do work for any of our clients. Okay? There are circumstances where it may, so if you've only got like 4 or 5 big clients, you know, that might be a case, but even then, it's a bit on the dicey side. Then there's also non-solicitation with regards to employees. You can't actively poach your former colleagues in order to start a new business or take them over to the competition. But you as a business owner, you cannot prevent your employees from resigning. They have not signed a contract of indentured slavery. People are allowed to resign. What's easier here is you can interdict both sets of employees if you find out they're going to set up a new business and they're going to compete with you and they're going to run against your competition and you've got a protectable interest and all of those things. So it's easier to interdict both parties there. Whereas with a client, you don't particularly want to interdict the client, but you only want to interdict the ex-employee. I hope that makes sense. Here, what you're essentially trying to do is to prevent the brain drain in your business. And you see this often in the IT world, where 3 coders decide to leave at the same time and decide to start their own business and write their own code in competition with their employer, or building on code that was written whilst they were employees. This is something that happens fairly often. And again, it is on a case-by-case basis. You can also go under the common law remedy of interfering with contractual relationships. But essentially, this is an easier one to spot and stop. But again, you've got to show that there's a threat to your business. And you've also got to define employees. It can't be anyone who has ever worked for me ever in their lives. So those kind of things are important. So how do you enforce a restraint of trade? Well, the one thing you don't do is nothing. Sitting at your desk going, oh, I don't know, shall I enforce it? Is it a good idea? Do I have any remedies? Oh, my neighbor Fred said you can never do this. That's not helpful. It's not helpful to anybody. So if you want to do something about it, make a decision, go and see an attorney and move. If you want to interdict somebody from taking a client or stealing any of your business or using anything that that threatens your protectable interest or any of your employees, you need to go now, today, immediately, and get legal advice. Because you need to bring an urgent interdict. An interdict is something that says, stop doing what you're doing. And to bring it urgently, you've got to show that you've only just got to know about it, or you've recently got to know about it. And that's by recently, I mean in like the last week. And that you moved quickly, that you didn't just leave it. Because after a period of time, if you leave the ex-employee to do whatever they want to do, and you know that they're busy building a new business that's in competition with you, you're going to struggle to get an interdict. Once it's all set up, you can't then go to court and moan and whine. You might have other remedies. For example, you might be able to claim damages down the line, which it does not have to be done urgently, but you're not going to be able to stop the behavior. You can't wing this. This is not something that you can just, fly by the seat of your pants. This really isn't. Because if you're going to bring an interdict, or you're going to write the right letter, or you're going to go and see the client, you need to know what your rights are. And you need to know how to do it. Because you can do more damage to your case by floundering around in the dark than by getting advice. I don't, for example, make up my own website, because I can spend 60 hours getting the wrong look and feel on WordPress, which I barely know how to use, or I can go to a professional and say, what do I need to design my website? Can you do it? And that is true for all aspects of business. I don't do my own accounting. I'm sure you don't do all your own law. I hope not, unless you're a lawyer. And hopefully you have someone who does your accounts, does your marketing. You do these things in a way that is helpful for your business. So coming back to damages, you can either claim damages immediately together with the interdict. So you can say, this is how much money I've lost. Or if you don't have enough information for an interdict, or you don't have urgency for an interdict, you can calculate what damages you have, and you can issue a summons down the line, and you can recover some of those damages. So not everything has to be done urgently, but what you do need to get is urgent advice. The number of times clients come to see me and they're like, yeah, I had this guy and he worked for me, and then 6 months ago he started his own business. That's too bad. 6 months ago may as well be 20 years ago in court years. So it's really important that you get that information as soon as possible. So how do you build an enforceable restraint of trade provision into your contract? Well, the first thing is you need to keep it as narrow as possible. Don't make it the broadest restraint of trade clause the world has ever seen, where you're like, nobody that has ever been a client ever in the world you can ever do business with in any country in the universe for 20 years. That is not going to fly, guys. You need to keep it as narrow as possible. Use different restraints for different employees. There's a different level of information that a CEO has compared to the cleaning lady. So they don't need the same restraints. They may not need any restraints. So just don't be lazy or careless and put high-level restraints in place for people that don't have access to that information. Then you need to clearly define your protectable interest. What is it that you are protecting and why? What is it that makes your business separate and unique? Ensure that your staff understand the provision. I would recommend that you have a special block for signature right next to the restraint of trade or the confidentiality or whatever it is. And every single time somebody joins your business, you take them through that clause and you make sure that they understand it. Because what you don't want down the line is someone going, oh, this was never explained to me, I didn't understand, I'm a poor and downtrodden intern. You need people to understand that provision. You also need to have a termination process that you can tell almost immediately when things aren't going your way. So if somebody resigns or if it's fired and they have access to information that is sensitive, you shut that person's access down immediately. You don't let them, if they've resigned, don't let them work out their notice period. You pay them for their notice period, but don't let them work it out unless you absolutely need them. Just do what you need to do to be sensible and to protect your business. And then, as I always say, prevention is better than cure. Don't leave confidential documents or information lying around that you don't want people to see. Make sure that you limit access to confidential information as appropriate. So my junior staff don't need to see the same things that my senior staff do. The documentation that I work on to create specific services for my clients are not available to my staff. The outcome is, but not the actual inner workings. And there's a reason for that. You may think that everybody's on board and everyone's on sides and everybody thinks you're an amazing human, but when relationships sour, they can go downhill very, very fast. So don't open yourself up to damage. So if I have a look at your poll and you say, yes, you have a restraint of trade, my question to you is it a restraint of trade that you understand? Is it a restraint of trade that talks to your business's requirements? Is it a restraint of trade that has been recently reviewed? And is it a restraint of trade that your employees understand? If you don't have one, is it because you don't know about restraints of trade, or you think it doesn't apply to you? Do you think maybe now it applies to you? Do you not know where to start? You need to answer those questions for yourself. And when it looks at enforcement, a lot of time people they decide that something is not enforceable before they know it's not enforceable. They decide that it's too expensive before it is too expensive. My advice to you is whether you use my firm or any other attorneys, you have to use them. You have to make sure that they are explaining things to you, that they are drafting agreements and provisions that make sense for your business. And that if the pawpaw hits the fan, that they're there to assist you, that they're there to take you through your options. So that's it from my side. I hope that I've helped to clarify some of the mystery around restraints of trade. It is not a simple area of the law, as you can see, but if there are a lot of attorneys, us included, who deal a lot with these and who are able to assist you and are able to talk you through this pretty much a minefield of law, and also bearing in mind that your risks are high when it comes to employees and shareholders and independent contractors and your protectable interests. The end. Does anyone have any questions?
There we go. First question from Todd. What about non-solicitation of suppliers?
Todd. That is going to be tricky. It depends on the circumstances. I'm assuming that your suppliers in that case are offering very specific services to you. You wouldn't, for example, be able to say Pick n Pay cannot supply cans of beans to your competitor. And there it would be less about non-solicitation of suppliers and more about ensuring, speaking to your suppliers, you should also have confidentiality agreements, and making sure that they are not providing any kind of specifications or information to your competitor or to your former employee that would have a detrimental effect on your business. You may be able to sign, and this would also be something you do in the beginning, exclusivity clauses. So you say to your supplier, when it comes to providing whatever it is, X, I don't know, specific machinery part, that you may only supply this to me. I will buy all these parts from you, but you may not supply to anyone else. So that wouldn't be a non-solicitation clause, but there are other provisions and other agreements available to assist you there.
Please give us real examples of what is confidential. Thank you, Claudia.
Okay, so Claudia, I know this is a very lawyer answer. It depends. But for example, you're calculating your billing structure would be confidential. So how do you put together your specific packages for your clients? That would probably be confidential. If you've got any specific software that's been made specifically for your business, that's likely to be confidential. If you've got any kind of specific ways of doing business that's unique to your target market. So in some insurance companies, there are products that no other insurer has cottoned onto or is able to provide. That would be confidential. In certain circumstances, recipes or trade secrets or know-how around how to produce a specific result or a specific item would be considered confidential. It would have to be something that, when it comes, this is purely confidential, confidentiality as opposed to a broader protectable interest. But when it comes to confidentiality, it needs to be something that really is only known in-house or is only known to a very select group of people. So known to, actually just known in-house, I think would be your safest bet. Todd, I don't mean to be funny, but this is, I actually don't have enough facts here. Again, it's going to depend on whether or not those suppliers are providing you with something that you are worried they will supply your competition with. And that is a slightly different question. I think it would be more helpful for us to have that conversation offline. But the bottom line is that if in your relationship with your supplier, there is something in that relationship that you want to protect, then there are ways that you can protect that. And you're not going to be able to prevent suppliers from doing business with other people unless you've got some kind of exclusivity. But you can't, so you've got to be careful how you do that. And it's not strictly a restraint of trade issue, from what I can see. Regarding restraint in the real estate industry. Okay, so this is one of the more tricky sides of it. I've only dealt with the real estate restraint once. You've got the same problem as most service professions, in that it's going to depend on who it is that's leaving, what information they have of that estate agency that is proprietary, and their client lists are important because essentially your client lists are your stock, and it's going to depend on geography. So you can't stop one from being, you can't stop somebody from being a real estate agent in the whole country if you only operate in one part of the country. And the other side of it is that you also can't, you can, for example, keep your restraint of trade period quite low. So you can say for 3 months or 2 months or 6 months, you can keep the time period fairly short, because by then you should have worked through your stock within a certain period. So real estate agents, accountants, lawyers, doctors, anyone where essentially you're dealing with relationships, those are much harder to restrain than other people. Oh, thanks, Jolene. Jolene's saying nice things to me. That's very nice. Thanks.